welcome back. You're listening to Passing the Baton. I'm Jared Hight from Tracktown Law, and today we're talking about the workhorse of modern estate planning, the Revocable Living Trust. Why so many Oregonians use one, what it can do for you, and where it falls flat. First, a quick disclaimer. I'm an estate planning attorney licensed in Oregon and Idaho, but this podcast doesn't make me your lawyer. Nothing here should be taken as legal advice. For that, you'll want to talk to a real human, ideally me, and you can start that conversation at tracktownlaw.com. Let's begin with the name, Revocable Living Trust. Not exactly marketing gold, but at least it's accurate. Revocable means you can change it, rewrite it, tear it up and start over. As long as you're alive and competent, you remain in control. Living means it's created during your lifetime. Not by your will, not by court order, just by you. And trust means a legal container that holds assets, managed by a trustee for the benefit of named beneficiaries. In practice, that trustee is usually you. You manage your own stuff just as before. But if you become incapacitated or die, control passes to your successor trustee without needing court approval or intervention. So the big question, why would you use one instead of a will? Well, because a will has one job. It's to tell the probate court what to do with your stuff. And probate, even in Oregon, is not especially fun. It's public, it's slow, and it's governed by statute rather than common sense. Even the simplest probate in Oregon requires a court filing, formal notice to heirs, published notice to creditors, an inventory, at least one accounting, and a court-approved distribution. That's the smooth version. Most take 9 to 12 months. Some take longer if real estate needs to be sold or a creditor shows up in month 4 with a claim that no one saw coming. Enter the Revocable Living Trust. A trust avoids probate. If your assets are titled in the name of the trust, there's no court process. The successor trustee steps in and follows your instructions, pays debts, distributes assets, keeps things quiet. This is a big deal in Oregon, where even modest estates can be subject to probate. Remember, our small estate affidavit only works if the estate is worth $275,000 or less, $75,000 in personal property, and $200,000 in real estate. It doesn't take much to cross that line. With a trust, you avoid the affidavit entirely. Assets pass without court supervision, and you control the process in advance. So what makes trusts popular in Oregon? Let's start with privacy. Probate records are public. Anyone with the right file number or enough time on a clerk's terminal can see your will, your inventory, and how you plan to split up the family antiques. A trust, by contrast, is private. Only the trustee and beneficiaries get a copy. Then there's efficiency. A trust avoids the statutory creditor claim period, it avoids mandatory accountings, and it avoids some of the court's more charming filing rules like original death certificates to be attached to every filing or demanding notarized receipts from every heir. Third is continuity. A trust operates during your life, at your incapacity, and after your death. If you fall into a coma, your successor trustee doesn't need to wait for a court to appoint a guardian or conservator. They simply take over management of the trust. With a will, nothing happens until you're dead. That's a problem when you're not. And finally, multi-state property. If you own property in another state, say a cabin in Idaho or a condo in Arizona, a will triggers ancillary probate in every state where real property is located. A trust avoids that. Title stays with the trust, and the successor trustee can administer it from Oregon, hassle-free. The catch, because of course there is one, a trust doesn't do anything unless you fund it. Funding means changing the title of your assets so that your trust, not you, owns them. For real estate, that means a new deed. For bank and brokerage accounts, it means new titling paperwork. For business interests, it might mean new operating agreements or ownership certificates. You'd be amazed how many people pay for a trust and never fund it. They die with a beautifully drafted binder on the shelf and all their assets still titled in their name. The result? Full probate. The trust is a ghost. At Tracktown Law, we walk clients through the funding process step by step. We prepare new deeds, we provide a customized checklist for bank and financial accounts, and we explain which things shouldn't go in the trust, like retirement accounts and certain beneficiary-driven assets. We also talk through the design of the trust, because a living trust isn't just about avoiding court, it's about control. You can, for example, stagger distributions to beneficiaries, like 1/3 at 25, 1/3 at 30, the rest at 35. Create discretionary trusts for a child with a substance abuse issue. Protect a child's inheritance from divorcing spouses or creditors. Hold a vacation home in trust for shared use by multiple heirs with ground rules for use, repairs, or sale. None of that fits inside a standard will. What it doesn't do, a revocable living trust does not reduce estate tax. It does not protect your assets from creditors while you're alive. It does not make you bulletproof in a lawsuit, and it won't magically clean up bad relationships or poor choices. But it does give you a private, flexible, and efficient way to pass assets and handle incapacity without making your family camp out at the Lane County Courthouse. So who doesn't need a trust? Well, if your estate is well under $275,000, you might not need one. If everything you own passes by beneficiary designation, PODs, TODs, retirement accounts, you might not need one. And if your family is highly functional, your documents are clean, and your assets are simple, a will-based plan might be just fine. But if you want clarity, privacy, or the ability to handle unique family dynamics without court involvement, a trust is often the better tool. If you're wondering whether a revocable living trust fits your situation, visit tracktownlaw.com and book a free consultation. I'll walk you through the pros, the cons, and how it would actually work with your real-life assets. Next episode, we'll talk about pour-over wills, what they are, why you still need one, even if you have a trust, and how they quietly clean up the loose ends. Thanks for listening.